Welcome to the Executive Compliance Blueprint. This is your definitive CISSP Domain 1 explainer, where we're going to take all that incredibly dense legal text and transform it into strategic risk governance. If you're gearing up for the exam, you already know that grasping the legal and regulatory landscape isn't just about memorizing a bunch of dry statutes. It's really about figuring out how to shield your organization, and honestly yourself, from immense liability. So today, I'll be your expert CISSP guide, walking you through absolutely everything you need to confidently crush those Domain 1 compliance and legal questions. Let's get into it. Here's our roadmap for today. Think of this as your CISO survival guide. We're covering categories of laws, cybercrime and frameworks, intellectual property protection, privacy laws, security control frameworks, and finally, risk and vendor governance. We'll also weave in those crucial import, export, and licensing rules you absolutely have to know. Okay, Section 1, Categories of Laws. Let's look at the foundation of the U.S. legal system. So, the crucial point to watch out for here is the classic burden of proof exam trap. Criminal law demands proof beyond a reasonable doubt. Why? Because an individual's freedom, and sometimes even their life, is literally on the line here, and the main goals are punishment and deterrence. On the flip side, civil or tort law only requires a preponderance of the evidence. That basically just means the jury believes it's more likely than not that the available evidence points to guilt. And it usually results in financial restitution to resolve a dispute, rather than throwing someone in jail. Now take a look at how the victim is defined in these different cases. It's super interesting. In criminal law, society itself is actually considered the victim to promote an orderly, law-abiding public. But civil law directly addresses wrongful acts between individuals or businesses, whether done willfully or just negligently, that result in some kind of damage or loss. For example, if one company sues another for ripping off their trademark, that falls squarely under civil law. And to round this out, we have administrative or regulatory law. This one's unique because it doesn't require legislative acts from Congress. Instead, it's enacted by the executive branch to dictate the exact compliance standards and regulatory enforcement that you, as a security leader, will be managing day in and day out. Think of agencies like the FDA, the FAA, or the FCC creating these rules. And make no mistake, violations here can result in severe financial penalties or, even imprisonment. Moving right along to Section 2, Cybercrime and Frameworks. Let's see how the law evolved for the digital age. The Computer Fraud and Abuse Act, the CFAA, is a huge focal point for the exam. Just look at the expanding jurisdiction on this timeline. It started out in 1984, strictly protecting federal computers. By '86, that expanded to federal interest computers and set a $5,000 damage threshold. Then, 1994 rolls around, and it explicitly outlaws malicious code and pulls in interstate commerce. Finally, in 1996, the National Information Infrastructure Protection Act broadened it even further to international commerce and elevated reckless acts against critical infrastructure to full-blown felonies. It's a massive evolution. When you step back, the sheer volume of legislation impacting our field is just massive. You absolutely must know the USA Patriot Act of 2001 and the USA Freedom Act, which amended earlier wiretapping laws, like the ECPA, to drastically expand law enforcement's surveillance powers. You also need to be totally familiar with FISMA, which mandates comprehensive security programs for federal agencies and their contractors. Plus, remember the federal Cybersecurity Laws of 2014. That officially designated the Department of Homeland Security as the central coordinator for federal cybersecurity, strongly enforcing NIST mandates. Okay, massive CISSP exam mindset note right here, so pay close attention. The 1991 federal sentencing guidelines established the prudent person rule. This is absolutely critical because it made senior executives personally liable for compliance failures if they don't act prudently. But it's not all doom and gloom. It also allows organizations to mitigate those penalties if they can prove they acted with due care and due diligence. Essentially, it places the responsibility firmly on senior management to govern risk the right way. Which brings us to Section 3, Intellectual Property and Licensing. How do we safeguard what we create? You absolutely have to memorize this matrix. Utility patents protect inventions for 20 years, while design patents last for 15. Both strictly require the invention to be novel and non-obvious. Trademarks? Those protect brands, slogans, and logos from consumer confusion, and they can be renewed indefinitely in 10-year chunks. Copyrights protect the expression of ideas, like your software code, and those last for the author's entire life, plus 70 years, or 120 years for corporate work for hire. Also, you need to understand your software license agreements. We're talking everything from shrink wrap and click through to EULAs, perpetual, subscription, open source, and concurrent cloud licenses. Oh, and finally, the DMCA. That prohibits circumventing digital copyright protections and provides safe harbor provisions for ISPs. Now, unlike patents, trade secrets never actually expire. But there's a big catch. They only stay protected as long as you use strict due care and NDAs to keep them hidden. Think of Coca-Cola's legendary recipe vault. The combination is supposedly only known to 2 employees, and it literally requires a board resolution to open the thing. If you slip up and fail to protect a trade secret, it instantly loses its legal status. Furthermore, the Economic Espionage Act of 1996 makes the theft of trade secrets a federal crime with massive penalties, especially if a foreign government is involved. Now, right before we dive into Section 4 on privacy regulations, keep in mind that if you're moving data across borders, you are subject to strict import and export controls. ITAR governs the U.S. munitions list, EAR handles dual-use commercial goods, and there are intense rules around exporting encryption to state sponsors of terrorism, though mass-market retail exemptions do exist. All right, with that in mind, let's look at Section 4, privacy laws and protecting user data. Honestly, privacy compliance is a total minefield. In the U.S. alone, you've got the Fourth Amendment requiring search warrants, and the Privacy Act of 1974 limiting federal record-keeping. You have GLBA for financial opt-outs, HIPAA and HITECH strictly guarding health records and enforcing breach notifications, and FERPA for student data. Then there's CALIA mandating wiretap backdoors for law enforcement, and COPPA requiring parental consent for kids under 13. Don't forget the Identity Theft and Assumption Deterrence Act, or the wave of state data breach notification laws that kicked off with California SB 1386. Oh, and a quick tip on workplace privacy. Those login banner warnings mean employees have absolutely zero expectation of privacy on corporate systems. Globally, the EU's GDPR is a game changer with its right to be forgotten, and it requires standard contractual clauses or binding corporate rules for cross-border data transfers, especially post-Trumps 2. And you also need to keep tabs on state laws, like California's CCPA and CPRA, Canada's PPDA, China's PIPL, and South Africa's POPIA. It is a lot to juggle. So, how do we operationalize all these legal mandates? That's Section 5, Security Control Frameworks. The NIST Cybersecurity Framework, or CSF, is a great voluntary foundation that maps directly to core functions: govern, identify, protect, detect, respond, and recover. But I want you to pay really close attention to the bottom 2 rows here. While NIST 853 provides this massive catalog of mandatory controls specifically for federal systems, 80171 is the contractual standard rigorously enforced on non-federal systems and government contractors. If your company handles government data, 80171 is your absolute strict baseline. Beyond NIST, you've got to recognize these other global standards to manage your overlapping compliance obligations. ISO 27001 is the gold standard internationally for managing your information security management system, heavily focused on continuous improvement. COBIT is essential for enterprise IT audit alignment. FedRAMP standardizes cloud procurement for the government. And here's a huge exam point. PCI DSS is a contractual standard, not a legal one, enforced by the payment card industry to protect credit card data across 12 core requirements. And the stringency of that compliance scales depending on your merchant level. All right. Finally, Section 6, Risk and Vendor Governance. Let's synthesize all these concepts. Here we go. This is the ultimate exam trap, and honestly, a concept even lawyers debate all the time: due care versus due diligence. Due care is the action. It's doing the right thing in the moment, like implementing a firewall or writing up a security policy. It relates directly back to that prudent person rule we talked about earlier. Due diligence, on the other hand, is the verification. It's the rigorous management, planning, and auditing to ensure that the action of due care was actually done correctly and is being maintained over time. If you fail to maintain that standard of due care, the result is what's called culpable negligence. If you don't act prudently, senior management can and will be held legally and financially liable. We aren't just talking about a bad day at the office here. It is a breach of legal duty that can result in catastrophic financial judgments against the company. And if a breach does occur, regulatory attorneys and auditors are going to use the principle of proximate causation. What that means is they will trace the attack all the way back to its root to prove that your specific lack of due diligence directly caused the data loss. It legally connects your failure to implement a safeguard directly to the negative consequences suffered by the organization or society. So, to wrap up our explainer today, ask yourself this mock exam question. If a cloud vendor loses your data because you completely failed to review their SLAs, their data segregation protocols, incident response readiness, or right to audit clauses, did you violate due care or due diligence? Well, the answer is, since you failed to verify the vendor's controls beforehand, you completely failed in your due diligence. Due care is simply having a vendor policy. Due diligence is actively auditing that vendor. Truly understanding that distinction is the key to passing Domain 1. So I'll leave you with this provocative thought. Is your organization truly practicing due diligence, or are you just blindly trusting your supply chain and hoping for the best? Keep studying, stay secure, and I'll see you next time.
All right, welcome future CISSPs. Today we're diving into an executive-level explainer designed to completely transition your technical mindset into a compliance-focused risk governance perspective. And this maps directly to Domain 1 of the exam. Listen, as an information security leader, you can't just think in terms of firewalls and encryption anymore. You absolutely have to think in terms of due care, due diligence, and legal liability. So let's get right into it. Here is your exact mental roadmap for the legal and regulatory compliance topics you must conquer for the exam. We're going to cover everything from the categories of U.S. law to computer crime, intellectual property, import and export controls, privacy, and finally, compliance and governance. Section 1. Categories of U.S. laws. To start, we really need to fundamentally categorize the three pillars of the U.S. legal system, because these dictate all of our cyber obligations. Criminal law is designed to protect society. Think of major hacking offenses here. The burden of proof is beyond a reasonable doubt, and the penalties can literally include prison time. Then you have civil law, which is all about dispute resolution and torts between entities. Here, an impartial arbiter uses a preponderance of the evidence, and the penalties are strictly financial. Finally, there's administrative law. This one doesn't require an act of Congress. It consists of rules and regulatory enforcement created by executive branch agencies, like the FCC, to govern daily operations. Now, here is a crucial CISSP exam mindset note. Always remember who enforces the law and what is at stake. In a criminal prosecution, the government brings the action. But in civil matters, it's totally incumbent upon the affected person or organization to file a lawsuit for financial restitution. Frankly, as a CISO, your exposure to massive civil lawsuits following a data breach is going to be the main driver for your security budget. Section 2. Computer crime laws and security frameworks. Let's trace how legislation has actually evolved to mandate organizational security over the years. Looking at this timeline, the 1984 Computer Fraud and Abuse Act, or CFAA, originally just protected federal interest computers, but by 1986, it was expanded to cover almost any computer used in interstate commerce. Then, in 1996, the National Information Infrastructure Protection Act made recklessly damaging critical infrastructure a literal felony. That paved the way for centralized mandates like FISMA in 2002 for federal agencies and contractors, and eventually the 2014 Federal Cybersecurity Laws, which established the DHS's coordination role and specific NIST mandates. You absolutely must grasp these foundational frameworks for the exam. NIST SP 800-53 defines mandatory controls for federal information systems, while 800-171 is crucial for protecting controlled unclassified information for government contractors. In contrast, the NIST Cybersecurity Framework, or CSF, is a voluntary, risk-based framework. But I want you to pay special attention to the 1991 Federal Sentencing Guidelines. They formalized the prudent person rule, requiring executives to take personal responsibility for security to mitigate and reduce regulatory penalties. And that brings us to another classic exam mindset note, and it's a common trap. Do not confuse due care and due diligence. Due care is the baseline. It's acting as a prudent person would. It's doing the right thing, like installing a firewall. Due diligence is the ongoing investigation and documentation that proves your due care is actually working. That's actively reviewing those firewall logs. You have to act securely, and you have to document it thoroughly. Section 3. Intellectual property and licensing. Now we're looking at how the law protects your organization's intangible assets. You need to memorize these duration rules. Copyrights protect the expression of an idea, like your software source code, and they last 70 years past the author's death.
or 120 years for corporate works for hire. Trademarks protect logos, slogans, and brands to avoid consumer confusion, usually renewed in 10-year periods. Patents protect actual inventions. Utility patents last 20 years, while design patents last 15. And remember, to get a patent, the invention has to meet the strict requirements of novelty and non-obviousness. Finally, trade secrets protect confidential operating knowledge indefinitely, but only as long as you take active protective measures like using NDAs to keep them hidden.
Contrast these two critical acts carefully. The Economic Espionage Act of 1996 gives true teeth to trade secret protection. It severely penalizes the theft of trade secrets, up to $500,000 and 15 years in prison, especially if it involves foreign government agents. On the flip side, the Digital Millennium Copyright Act, or DMCA, focuses on anti-circumvention. It makes it totally illegal to bypass copy protections on digital media. Crucially, the DMCA also creates a safe harbor provision, which limits the liability of internet service providers for the transitory, everyday activities of their users. As an executive, understanding software license agreements is paramount for avoiding contractual civil liabilities. You've got perpetual licenses, which are a one-time fee for indefinite use, versus subscription models with recurring, time-bound fees. You also need to manage concurrent licenses, which limit simultaneous users, versus specific named user licenses. Open source offers freedom but comes with strict usage conditions, while enterprise licenses cover the whole organization. And beware of shrink wrap, click-through, and cloud service EUALs. An employee might unknowingly bind your entire organization to a legally enforceable contract just by clicking "I agree" on a web prompt. Here's a highly strategic exam mindset note. Registering a patent publicly reveals your invention to the world. Copyright only protects the literal text of the code, so a competitor could just rewrite it in another language. Therefore, treating your core algorithmic logic as a trade secret and enforcing that through strict access controls and NDAs is often the absolute best strategic choice for proprietary software.
Section 4. Import and Export Controls.
As your business scales globally, you're going to run into strict federal regulations governing the export of sensitive tech. Let's clear up a very common pitfall right now. ITAR is strictly for controlling military and defense items listed on the United States Munitions List, or USML. ER is much broader. It covers dual-use commercial goods on the Commerce Control List, or CCL. Crucially, ER restricts the export of strong encryption software, particularly to state sponsors of terrorism, though mass-market retail software is generally granted an exemption. Don't mix those two up.
Section 5. Privacy Laws and Concepts.
This is a dense, rapidly evolving landscape where legal boundaries literally dictate our technical architectures. The U.S. takes a sectoral approach to privacy, meaning you have to match the specific law to the industry. We've got the Fourth Amendment requiring warrants for search and seizure, the Privacy Act of 1974 putting limits on federal agency records, the ECPA in '86 prohibiting electronic eavesdropping, then CALA in '94, which actually mandated wiretap backdoors for law enforcement. For sectors, there's HIPAA and high-tech protecting protected health information, or PHI, and establishing business associate liability. We have COPPA requiring parental consent for kids under 13, GLBA for financial institution privacy notices and opt-outs, FERPA for student educational records, the Identity Theft and Assumption Deterrence Act, which criminalized identity theft federally, the USA Patriot Act and USA Freedom Act dictating surveillance powers. Oh, and don't forget workplace privacy. Employers use banner warnings to establish ownership, meaning employees have zero expectation of privacy on corporate systems. Like I said, it's a massive patchwork.
But privacy is borderless, right? Internationally, the EU's GDPR is the comprehensive global standard. It has 7 core principles and establishes deep data subject rights, including the famous right to be forgotten. If you are doing cross-border data transfers out of the EU, you have to use mechanisms like standard contractual clauses, or SCCs, binding corporate rules, or navigate the Schrems II ruling and the EU-US Data Privacy Framework. You also need to comply with Canada's PIPEDA for commercial data, China's PIPL, and South Africa's POPIA. Back in the States, we have robust consumer privacy laws like California's CCPA and CPRA, which grant explicit consumer opt-outs, access rights, and anti-discrimination protections. Check out this exam mindset note. Notice how U.S. federal law only requires data breach notifications for specific industries, like healthcare under HIPAA. But all 50 individual states have their own overarching breach notification laws, a trend pioneered by California's SB 1386. So if your system gets breached, you aren't just dealing with one federal law, you are actively navigating the specific notification mandates of every single state where your affected customers happen to live. It's a logistical nightmare if you aren't prepared.
Section 6. Compliance and Industry Standards.
Your real-world executive challenge is audit alignment, harmonizing all these overlapping legal, regulatory, and contractual obligations. A perfect example of a strict contractual standard, not a federal law but a contract, is PCI DSS. It applies to any entity across different merchant levels handling credit card data. Its 12 core requirements mandate things like explicitly changing vendor-supplied default passwords, encrypting cardholder data during transmission, regularly updating your antivirus, and restricting access strictly by a business need to know.
And this flows directly into contracting, procurement, and vendor governance. Outsourcing your cloud supply chain does not mean you're outsourcing your ultimate risk liability. You have to integrate security from the start. That means conducting initial security reviews during vendor selection. It means guaranteeing strict data segregation so your data doesn't accidentally mix with another tenant's. And critically, you have to embed service-level agreements, or SLAs, and right-to-audit clauses into the contract to verify their encryption standards and incident response readiness.
As an information security leader, your primary duty is safely guiding your organization through this insanely complex, rocky landscape of overlapping jurisdictions. You are literally the bridge between the highly technical teams mitigating software vulnerabilities and the legal teams managing corporate risk. You must ensure that your security policies translate into verifiable, documented due diligence.
So, as we wrap up this explainer, I want you to ask yourself a serious question. If a cloud vendor experiences a breach involving your European customers' data today, are your vendor governance and incident response plans truly ready to demonstrate due diligence across both your PCI DSS contracts and GDPR regulations? A breach isn't just a technical failure anymore. It is a massive international legal incident. You need to ensure your frameworks are mapped, your vendors are audited, and your due diligence is absolutely unquestionable. Keep studying, stay focused, and I'll catch you in the next Domain Explainer.